Okay. Now, why does this matter? Why does the purpose of, so if I have a lot that's 50 by 100 square feet, I have a 5,000 square foot lot, the 5,000 square foot lot, I'm going to use a 10 FAR because 10 FAR is a round number. It multiplies easily. I could build a 50,000 square foot building, right? Everyone understand? Now remember, when you're measuring the zoning resolution, and that 50,000 square feet, just to be clear, is only floor area, not the total size of the building. So I might be able to build a building on this lot in and of itself, without merging anything, that has 65,000 square feet. Maybe I have 2 levels of cellar, and maybe I have some mechanical space in there, or I have some other spaces that don't count as floor area. Right? So my building is not limited to 50,000 square feet. My floor area, FAR only controls floor area. A building itself could be larger. Okay. I'm going to make this fairly small. 50. Very well, but we'll just treat it like this. 10, that's 100, just not to scale. Put it as you can clearly see. Oh, this is 100 and this is 25. Okay, so this is my block. Oh, the other thing in the definition is it has to be located on a single zoning block, on a single block. In order to merge, they have to be contiguous for 10 feet and located on the same block. All right. Now, right, so if I have a lot that's 5,000 square feet, I can build a building that's 50,000 square feet. If my lot is 10,000 square feet, I can build a bigger building that's 100,000 square feet. So as I increase the lot size, I can build a bigger building. So we're going to assume for this exercise that there's a 10 FAR, there's all 10 FAR, but we're going to assume that this is residentially zoned and this is commercially zoned. All right? All a 10 FAR. Okay, so just some language, development rights. The zoning resolution does not at any point, anywhere, use the term with respect to this development rights. It doesn't use the term air rights. The zoning resolution refers to floor area. Development rights is what we, the public, what all of us, lawyers, non-lawyers, refer to as the development rights or your capacity. So my development rights, I have 5,000 square feet of floor area, but it's also referred to as 5,000 square feet of development rights. I'm sorry, 50,000 square feet of floor area, 50,000 square feet of development rights. I have the right to develop 50,000 square feet of floor area. That's my development rights. Unused if I have a building here that has, I can build if I have a 10,000 square foot building already there, I have 40,000 square feet of unused capacity, which are called air rights. I have 40,000, but again, it doesn't define, it's unused floor area. That's what it is. It's unused floor area. Air rights are unused floor area. This is from a picture Now, this is a very good drawing that shows it, right? So air right, what is an air rights transfer? It's the transferring of the unused capacity, the unused floor area, or air rights to a neighboring property on my zoning lot. So, in order to take advantage of this, you have to be a single zoning lot. Well, I'm contiguous for 10 feet. I can do that, yeah.
So I wrote about 200 Amsterdam.
200, we're not gonna talk about, I'll give you, so, yes.
Basically, it's like, even parts of zoning lots could potentially be sometimes considered,
Okay.
be able to be merged.
Yeah,
even if-
I don't actually agree with that decision. I don't agree with the BSA from a legal perspective. The zoning resolution itself doesn't use the term portion of the zoning lot. The zoning resolution only uses the term zoning lot. But in the early 80s, the DOB commissioner was named Irving Minkin. And you hear often about various things called Minkin memos. There's lots of Minkin memos on all kinds of subjects that related to zoning. He was a very smart man. And in the Minkin memo, he says something about portions of zoning lots. And because he said portions of zoning lots, the Department of Buildings has in a handful of cases, including 200 Amsterdam, which dates back to the early 80s, might date back to the late 70s, took the position that if it's, you could merge portions of zoning lots, not just entire zoning lots. I don't agree because the zoning resolution doesn't say that, and I think the BSA is, I think it's wrong. Because the zoning resolution doesn't say that, and that a memo can't override the plain language of the zoning resolution. No, I could be wrong, and so far the court, the BSA hasn't upheld me, right? The court has. And it could be that the court, at the end of the day, I'm sure this is gonna stay in court. At the end of the day, it could be that the court determines in fact that yes, because that it was a reasonable interpretation by an agency charged with interpretation, which is what the argument is, it's a reasonable interpretation, and that it's okay. Or they may not, I don't actually know. Whatever they decide will be what they decide, and that will be the rule. But for now, based on the BSA determination, portions of zoning lots are okay. And I haven't read, I don't know if they've actually issued a written determination yet when it came back to them last week.
Well, they said.
They said yes, but they're gonna issue a multi-page resolution that's going to explain all of their thinking, which if you watch the hearing, you'll see what it was, but I didn't, so I'm gonna wait till I get that here, that.
I have it.
You have the resolution?
Yeah.
Can you send it to me, please?
Yeah.
Thank you. Okay, now did you have a question?
Yeah, so the slide describes how unused development rights can be shifted from one lot to another, and I guess typically adjacent lots, but are there also pass-through?
Okay, so, right, the air rights can only be transferred by adjacent zoning lots. I mean, adjacent properties. You can't create a zoning lot unless the properties are adjacent. But I could create a zoning lot with all of these lots on it. My zoning lot could look like, can't look like that, because the pen doesn't work. My zoning lot could look like, well, it can't. My zoning lot could look like, that could be my zoning lot, right? Could be multiple lots in my zoning lot. I could have a zoning lot that encompasses the entire block. So, you can create a zoning lot out of any properties as long as they're contiguous for not less than 10 feet.
And there's nothing known as like pass-through, or?
Well, that we'll get to in a second, what that means. Okay, so in order to use development, in order to do this air right transfer, you have to be on a single zoning lot. So, owner A and owner B, right? Let's forget this zoning lot. Okay, forget that zoning lot. Okay. So, owner A and owner B. Owner A wants to develop. And so owner A wants to buy development rights from everybody they can. Okay, because I have this, I don't have really the space. So let's assume that owner A, so this is 50,000. Let's assume that owner B, right, this will be owner B, can build 50,000 square feet and has an existing 25,000 square foot building. Okay? So that means there's 25,000 square feet of development rights available from lot B. Okay? Let's call this, well, let's give it tax lot numbers. Tax lot 1, tax lot 2, tax lot 3, 4, 5, 6, 7, 8, 9, 10, 11. All right, that's enough. So, owner A wants to buy 25,000 square feet from owner B. Owner 3, so owner of lot 3 has, let's assume that each of these, well, owner 3, 4, and 6. 75, so this is 75. Owner 3, 4, and 6 each have, right, they're 25, they can build 25,000 square foot buildings, and each of them, for simplicity purposes, has a 15,000 square foot building, and they each have 10,000 square feet extra. No, yeah, each of them has 10,000 square feet extra. Now, owner 5, right? Oh, so we have a 75 by 50. I should have done simpler math. So 75 by 50 plus 25 by 175. I don't know what the math is. I should have drawn this differently. Let's assume that whatever the floor area that's built here, there's 0 excess. That's all we mean. For the purpose of this, all we care about is that there's 0 excess. Now, we have this guy who also has an enormous 100. So this is 200 times 50 is 10,000, plus 75 times 75 is, who can do the math in their head? Or quickly on their calculator?
75 times 75.
Right, because this is 75 times 75.
5625.
5625, so they have a lot that is 5625, so they have a lot that is 10,000, right, this is, I'm sorry, so they have a 10,000 square foot lot plus 5625, so that's 15,625 is what the lot area is here, so they could build a building of 156,625 square feet. Let's assume the building on this lot is 175,000 square feet. It's overbuilt, right? So we have 175,000 minus 156,250, and we have 750 plus 175 minus 156 is 19. They're overbuilt by 19,750 square feet. Right? Now let's assume this lot, let's assume they're owned by the same person to make this a simpler project. 25 by 200 would have given them a 10,000 square foot lot. No, 25 times 200 is a 4,000, is 25,000. It's a 25,000 square foot lot. I'm sorry, 25,000 square foot floor. And let's assume they have a landmark building here and they only have 2,500 square feet built. So 25,000 minus 2,500 is 22,250 square feet. Everyone following me? More or less, right? This guy has, these two lots have 22,250 left. This guy has a deficiency of 19,750, okay? Everyone understands that? And let's assume, there's a big lot, a 10,000 square foot lot. Let's assume there's 60,000 square feet of floor area here available. So I've written down all the floor area available, all right? So this guy has 60,000 available. Because they could build 100,000 and they have, all right. We could merge with all of these. And this developer, right, the developer wants one, he could buy 25,000, oh, I didn't do this one, this would be 75 times, 75, which we discovered is 56, 25, which is 56, 250, and let's assume there's 10,000 square feet extra here, right? So, this guy can merge with him, right, he could buy the 25,000. He could merge with her and buy the 10,000 square feet. And none of these are big numbers, are they? Where does he really want to get his floor area from? Over here. But in order to get to this lot, he has to go through this lot. Now he wants to build a residential building, this is important, okay? So he's building a residential building and he wants to buy all of this floor area. In order to get the 60,000, which is really where the excess is, right, that's where there's big extra floor area, he's got to go through this lot. Can he do that? Yes, he can do that. But all it means is when he's thinking about buying the 60,000 from lot 13, so he's buying 22,250 from here and 60,000 from here, that's 82,250. In order to acquire that, he's got to deduct from that number 19,750.
Because it's overbuilt?
Because he's overbuilt. That's why there's a minus, because right, this is overbuilt. So you can, and then this might be considered a pass-through, or if for some reason the developer was up here and was buying air rights from here, this might be considered a pass-through because you're not getting any development rights from that lot.
How does that pass through work?
It just means you're not getting any development rights from them.
But how can you get development rights from the next lot?
Okay, you can buy development rights from anybody as long as you're a single zoning lot. So I create a single zoning lot from my new single zoning lot. This is my zoning lot. This is my single zoning lot. Oh, maybe I forgot. I have this guy in it.
But you own all of them now.
I don't own any of them. I only own lot 1. I am the developer. I only own lot 1. I'm creating a zoning lot that consists of lot 1, lot 2, lot 7, lot 8, lot 9, lot 12, and lot 13. I only own lot 1. I can do that.
How?
Okay, so the first step is you have to create the single zoning lot, right? If I don't bring lot 13 into my zoning lot, I can't buy excess floor area from them. Yeah.
But by merging, aren't you consolidating ownership to?
No, 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 no,
You're
no.
creating
No.
one tax lot, right?
No. Zoning lot is not the same as tax lot. After I've created this zoning lot, my zoning lot will have 1, 2, 3, 4, 5, 6, 7 tax lots in it. A zoning lot merger does not merge ownership, and it doesn't merge tax lots. So all of these lots will continue to be owned by their owners, and will continue to have whatever leases are on them, and will continue to have whatever mortgages are on them. I mean, I'll talk about how we do this, the process of getting them merged, but at a zoning lot, after you've merged, you have not changed fee ownership of any of the properties. Okay, we've got 3 questions. Alex?
Doesn't that affect everybody that owns a parcel in that zoning lot? Like, do they have a say in what you do as the owner? of
Okay, we'll get to
parcel
that, that'll get to come, that question's coming up.
How did St. Patrick's sell their air rights?
St. Patrick's did it through a landmarks transfer, which is different. There's a special provision in the zoning resolution allowing landmarks to transfer floor area either across, originally it was just across the street,
Right.
but in Midtown it allows for a bigger transfer throughout other portions of Midtown.
So it wasn't like.
Not through this. It is not done through this, it is actually done through a special permit process. And you had a question?
Yeah, two parts. You buy it from the owner of the property, right? That's what you're doing, you're buying the air rights,
Yes.
development rights?
So you, owner of lot 2, are going to sell me, owner of lot 1, 25,000 square feet of your air rights,
And
and I
that
pay
gets-
you some money.
That gets changed on the zoning map?
Doesn't get changed anywhere.
Where does that live? How does the city know that exists, or that?
The city, buildings department knows, but let me go through this process, okay. So, how do I create a single zoning lot? So the legal document that creates the zoning lot is called a declaration of zoning lot restrictions. This is just, to answer your question, this is how a landmark transfers. Can transfer it across the street. Okay. Let me see if I have. Let me see if I sent my.
Oof, you gotta clear your inbox. It's giving me anxiety.
I don't go in there much, I just leave everything sit, I don't.
Oh, man.
Well, how many do I have in there?
You need an intern? Let me know.
I never look at most of them, I just leave it. What can I say, I'm not I don't have, I thought I had somewhere here, so I'm just gonna close this. So, let's go, I know where let's go. Let's go to the zoning. Okay. I'm trying to get this up, okay, so. Here's the definition of zoning lot in the zoning resolution. There we go. Okay, so. We're gonna talk, so really, when we're doing this, people call it a type D zoning lot merger. That's what all of these mergers are. When Extel bought air rights from everybody on the block, that's what they did. Okay. So, or it's also, people call it a declaration of zoning lot restrictions, but it could just be called a declaration of restrictions, right? That's what it says in the zoning resolution. A tract of land, which at the time of filing for a building permit, that's when you look DOB checks. That's when DOB checks. Did you file a declaration of zoning lot restrictions or declaration of restrictions that shows that it is a single zoning lot? So, shall be made in one declaration of restrictions covering all of such tract or in separately written declarations. So, I could enter into a declaration of restrictions with lot 2, and I enter into a separate one with lot 7, and another one with lot 8. Or I enter into one with everybody, and I have a declaration of restrictions. And the declaration of restrictions when I'm all done, will say that my zoning lot consists of all of these tax lots. And that declaration will be recorded, like a deed is recorded, right, on ACRIS, right, in the property record, in the records, or in a finance, ACRIS. But look at the second piece of this. Shall be by each party in interest. So who has to sign that declaration? Every party in interest. But it goes on to say, accepting such party as shall have waived its right to execute. Okay, so every party in interest has to sign the declaration or has to waive their right to execute the declaration. So, who are party in interests? Owners are parties in interest. Mortgagees are parties in interest. Ground lessees, not space tenants, only ground leases. I mean, there could be others, but those are really the most important ones and the major ones. So, you have a lender, right? every one of these properties probably has a lender. They might have two lenders, they might have two lenders, right? They might have two lenders. They might have the IDA because they got some kind of a tax abatement from the city for commercial use in certain cases, in which case they might be a party in interest. So every party in interest has to sign a waiver. I, lender on lot 2, waive my rights to sign a declaration of restrictions to merge lots 1 and 2. So that's what creates. So we've created the zoning lot, and all the lenders have waived their rights to sign, and any ground lessees and anybody else who's a party in interest. Who determines who the party in interest are? The title company. People talk about exhibit 1s and exhibit 2s, you hear this term. Those are what's called a party in interest certification prepared by the title company. It's like a title search, but it's very limited. All it shows are the parties in interest. So the zoning lot certification for this lot will say lot 1, owner, Robin Kramer, lender, Jace. Lot 2, owner, Jane Smith, LLC. Property owner, lender, Jace, right? Lot 7, owner, trustees of the George Hamilton Trust. Lender, right, mortgagee, lender LLC. And that's what the party in interest, that's what the zoning lot certification will say. Okay, so we've created the zoning lot. And there are a lot of extra floor area floating around this zoning lot, right? 25, 35, 95 plus 22 minus 1970, so let's say more or less 95, about 98,000 square feet of excess floor area on the zoning lot, correct? And this is a vacant lot, so there's 50,000 here. So it's 148,000 square feet of excess development rights existing on this zoning lot. And I'm this guy. I'm this owner. And I say, you know what? I'm gonna use that 148,000 square feet of floor area. Can I? Can I use that 100? No. All we've signed so far is a declaration we've created a single zoning lot. Can I use that 148,000 square feet on my zoning lot?
No, because there would be a contract of sale, right?
But a contract of sale says, I'm gonna sell it to you, right? Contract of sale, right, well, so what do you have? First you have you generally, but let's just leave that aside for a minute. All that's happened is everybody has recorded the declaration of one giant zoning lot. And a contract of sale, generally at a closing, disappears. Right, doesn't survive, so after the closing, the contract of sale generally goes away. There might be some survival provisions.
No, I meant for those development rights, the contract.
Contract of sale just says, I'm gonna sell them to you. So now we've closed, and in theory, and I have all these contracts of sale. We've closed, you've sold me them. Nevertheless, I go to the Department of Buildings with an application to build to use that 148,000 square feet of floor area on my lot. Can I do that? And why not? Or can I, or can't I?
With the new declaration, would it have just that owner and lender's name at the corner lot? Or would it have everybody's on it?
Well, every declaration is going to, I don't know whether, they might have had, 1, 2, 3, 4, 5, 6 declarations. They might have had one declaration. At the end of the day, this is one zoning lot with as many declarations as are needed.
But there's still a grantor and a grantee, right?
A declaration doesn't have a grantor and a grantee. A grantor says, Owner A, owner B, owner C, owner D hereby declare that the zoning lot comprising lots 1, 2, 7, and 8 shall be considered a single zoning lot for all purposes under the zoning resolution. In witness whereof we have hereunto set our signatures. Nothing in there about anything else. The answer is, yeah. They could go to the Department of Buildings and file an application to use that 148,000 square feet floor area. There is no, theoretically you say, but wait a minute. I paid everybody. There's no case law. There's no document that shows that. There's a contract. Okay, so how do you protect yourself? How do I protect myself? I enter into something that isn't a product of the zoning resolution, called generally a zoning lot development agreement or a zoning lot development and easement agreement. The declaration creates the zoning lot. That's all a declaration does. The Zelda is the document that allocates rights, obligations, responsibilities, etc., and the floor area under zoning resolution, on the zoning lot. So the Zelda will say that everybody sold it to me, and that's how I own it. And there is no case law where one property owner, you didn't have a Zelda, and people do this sometimes. In fact, let me tell you about an example. I don't know if you can see over here, but we're pretty much done with this. So let me close this and let me go to, because we don't need this anymore. A Brooklyn site. Brooklyn property in like an R6 district, not a particularly high density district. There was it was originally a manufacturing district. At some point it got rezoned. This was lot 1. Originally this was all lot 1. In 1990 something, lot 1, there was a building here, and there was nothing on. These were vacant, right? It was a giant lot. Whoever was, the owner of this had a manufacturing building, and at some point, maybe they used all the other lots for something in connection with their manufacturing, but no longer. And so he wanted to sell the rest of the property for development. So he divided his property into 5 lots. That's a 5. So he's dividing his tax, right? This is what he was interested in, selling the tax lots in order to sell a tax lot. In order to sell property, you need to create a separate tax lot. So this was all one tax lot, created separate tax lots. And when he went through the process that you go through for this, the Department of Buildings said to him, look, we're not going to let you create separate tax lots unless you declare this to be a single zoning lot. Right? Because it was a single zoning lot before any of this happened, but if nothing said it was a single zoning lot and he'd created these separate tax lots, they would have been separate zoning lots as well. So, a covenant, there was it wasn't a declaration of restriction, but it was a kind of a covenant that was recorded against all of these lots that said there's a single zoning lot. All right. Fast forward so sold all of the lots. I said the lots were in, but there was a building. There were a couple of existing older buildings. Let's assume these had, I don't know how much they had, but let's assume this could be built, this one could build 50,000 square feet, and let's say each of these could build 25,000 square feet. These 2 were vacant. Let's assume that's what it was. I don't remember the numbers. Yeah.
Typically, if I sell my property, if I own 1 lot, do I typically sell it?
No, if you're selling your 1 lot, nothing's changing.
But I sell the physical, I sell on the tax map, I guess nothing changed on the tax map, but I sell my lot and I sell the zoning rights.
When you sell land, you sell all rights pertinent to that land, including development rights, unless you somehow expressly restrict them. So if I'm the developer here and you own this lot, and you wanted to sell the fee to somebody else, but you wanted to retain ownership of the 25,000, you would have to create a fee above a plane and own. You have to own land. You can't own development rights unless you own essentially a tax lot. I can't, if you sold all of that land, whoever you sold it to would own everything. In order for you to keep these 25,000 square feet, you would have to create on the tax map a fee above a plane, which are lots designated by, beginning with the number 9, airspace parcels. Okay, but that's not, so let's go back to this. So there were, as I said, there were a couple of buildings, smaller buildings here, and these were vacant. Purchaser of lot 5 went to the Department of Buildings and got a building permit to expand their lot to build 50,000, to build, let's say 60,000 square feet of floor area. Remember, we had lots of floor area left on the zoning lot, so they could build 60,000 square feet. They went to the Department of Buildings and they got a building permit to build, that would be 75,000, they had 67, to build 60,000 square feet. There's 15,000 square feet left. They went to the Department of Buildings, they got their 15,000 square, they built something. This guy bought the lot. What was left for him to build? What was left for him to build?
I'm missing the math, sorry.
Nothing. He didn't know that, because the title company screwed up, and when he did a title report on the property, they didn't go back and look at the lot as it had existed in 1990. They only looked at the lot, they didn't go back to the larger tax lots which the title company was supposed to. When he bought this lot, he had no development rights left. He ended up having to enter into a deal with some of these, they hadn't built yet, to sort of buy back, and so it happens.
So whose responsibility is it to, when you wanna buy a lot, to make sure that there are?
Your responsibility.
But I don't know anything, so who?
It's all on title. I go look at the title. Title report, this title report, the title report should have gone back, and since the lot was only created in 1992, they should have gone back to, whenever, 1800, by looking at the bigger tax lot.
Yeah.
That was a title company screwed up.
And you have
But it's my responsibility, would have been my responsibility as the owner to make sure they did that, or the lawyer to make sure they did that, but it's the title company really screwed up.
Gotta get title insurance.
But title insurance didn't cover anything, there was nothing, title insurance was selling a piece of land. Title insurance does not insure that you get any floor area, all it insures is that you get land with whatever's left on it. And they didn't actually right, so.
Wait, so in this scenario, let's say it's vacant, and they sold all their rights, you can't build anything, not even 1 story?
Can't build anything, I don't have any floor area left.
How does one go about marketing air rights? Like, is that a game? Do people do that? Like investors?
People market air rights all over the city.
Yeah, but
There's
like
a
as
couple
a
of,
strategy, like full blown, like I'm gonna only.
well,
buy
remember, I
property
can only
sell
sell
their
to my
rights.
neighbors, so I'm this person here. The only people who are gonna buy from me, 1, 2, 3, there's nobody else I can sell to. I mean, at the end of the day, if somebody's doing a big development, I might be able, if this is Extel, right, and they're doing a development here, I might be able to sell. But I wouldn't necessarily know that, so if I wanted to market them, I could get a broker. Brokers do this, there's a couple brokers who really focus on this.
And so you wanted everything to be in the zoning map for what reason?
It's not on a zoning map,
I mean,
none of
zoning.
this is on a zoning map.
You zoning, yeah, like that little thing that you just did, not ownership, doesn't, right, it's supposed to uniform the zoning, right? That's what it's supposed to do?
I'm sorry?
You're supposed to unify the zoning for those.
No, you haven't
parcels.
unified the zoning, all you've done is created a single zoning lot.
So what does that mean?
That means that all calculations, right, if my FAR is 10, My FAR of 10 is calculated across the whole zoning lot. If I'm looking at height and setback regulations, let's look at yards. There's no longer a rear yard here, because it's now a single lot, so there's no rear yard here. So all of the provisions of the zoning resolution are now measured against this thing.
It's not based on parcel, it's based on this thing that you created.
It's based on zoning lot, right? That's what I was saying. So this is my zoning lot. Everything in the zoning resolution is going to be measured against this zoning lot, right? Every provision in the zoning resolution applies to zoning lot. A zoning lot shall contain not more than, every zoning lot shall be this. The height of any sometimes it says building, the height of any building, the height of all buildings on a zoning lot. Everything in the zoning resolution is by, sometimes it's building, but generally it's by zoning lot. And that's why you do this, so that the provisions of the zoning resolution apply to me as a zoning lot.
Is this similar to an assemblage?
There's an assemblage,
Assemblage, yeah.
it's an air rights assemblage. Here's what Excel did to build its building. That's what 435 Park, that tall, right, the building, 432, sorry, 432 Park. They bought air rights from all the buildings around them and built this very tall and skinny building.
Wait, so you're saying that if you create the zoning lots, you don't need to be next door to someone to get there?
The zoning lot,
Adjacent.
everybody's contiguous, but I don't need to be next door to them to use their floor area, because they're in my zoning lot.
Got you.
Now, if 7, 8, and 9, and 12 weren't in my zoning lot, I couldn't have bought these air rights.
Gotcha.
That's why I had to consider the impact of having this overbuilt building in my zoning lot.
Then how do you incentivize the people in between? I figure like everybody
I'm
needs to
paying
get
them
their.
money.
Okay.
As you get closer to the end, it goes up, right, in price.
No, usually you don't do it that way. Usually you enter into your deals
Individually.
individually.
Well,
And I might enter into this deal first, because that's where I wanna get.
true.
Yes, I haven't entered into a deal with this, it's a
It's-
game,
it's
you have to figure out how to
conditional
play
on
the
you-
game.
Right, but if you enter in that agreement, first, it's all
But it's-
contingent on you getting the other guys on
Correct,
board.
and nobody's ever gonna make it contingent usually, I don't know, I haven't seen that, somebody could.
They
but-
won't be transparent.
But look, it's not transparent, nobody knows, it's a contract, contracts aren't recorded. Contracts have confidentiality provisions.
Do the other lots have different FAR?
Okay. That's a good question, let's talk about that. In order to transfer floor area, you can only transfer floor area from a lot that has the same FAR for the same use.
It doesn't matter that you had that residential.
Aha. So, the 10 FAR for everything, it does matter. So if I wanna build a residential building here, that's fine, cause it's 10 FAR for everything. If I wanna build an office building here, I cannot buy any floor area from them, because it's not permitted, that's not the use. They can only transfer floor area for residential use. So I'm building a residential building, I can buy them and
What
can
if
use it.
there's an overlay?
I'm sorry?
What if there's an overlay?
It doesn't matter, it's a residential district, if this has an overlay, then it might limit it, because commercial use here is limited to 2 FAR, let's say, for the overlay. So I can only, but it's not the same FAR, it's a 2 FAR, not a 10 FAR. So you have to do the same 10 FAR for the same use. So this is a C district, this is an R district, I could transfer 10 FAR, not the whole 10 FAR, but use the FAR 10, use the 10 FAR to calculate. And I could buy that 60,000 square feet for use here if I'm building a residential building, but not if I'm building a commercial building.
This might be like a tangent, but how do you price air rights? Is it just like?
It's a negotiation, but, there's a lot of, there's half of the land price. Because remember, you're getting to go up and build bigger, so it's more valuable. It's like the last dollar, not the last dollar, it's the last footage in your building. It's your tallest.
Penthouse floors.
I'm sorry?
Penthouse floors.
Exactly, and which are the most valuable. So, half of the land value, something like that, is a ballpark. But in any site, it's going to sort of vary based on where you are, what can be built, what other people have sold for.
And
It's
for.
not a fixed, there's no, is it, half of the, is sort of like a reasonable approximation,
Yeah.
but it's not, just like land price. When I buy this lot, you know, let's say the land value here is $100 a square foot. That guy's greedy, they want $125 a square foot. I may be willing to pay them because of my potential for development, but I may not be willing to, but somebody else may be. So it's like everything, it's all negotiation.
It's almost always less than the value of land though, right?
It's always less than the value of land. The only place it ever wasn't was in West Chelsea for a while. It was more than the value of land, but very limited period and very limited,
And when you're paying the contiguous, like, you know,
the land.
people in between, I guess that's just varies by the person, it's just how
So,
much you're
you
willing
mean
to
the,
pay
the,
for
guy-
it.
the one here that was overbuilt?
Yeah, I don't know, any of them, like, how
Well,
do
this
you
is
go
what
about
it's,
that?
so I've got $100 a square foot lot, just cause it's a round number. So the price of the land would have been 10,000 times $100 a square foot, that makes us $1 million, right? If I've done this right, that would make this $1 million.
No, I mean, like, let's say you're trying to get to lot 13, and you gotta pay for the people in between to be like, hey, be part of my zoning.
Well,
map.
if I'm gonna use their floor area, then I'm paying them for their floor area.
Wait, you're not just building on your own lot? You're not just building higher on your own lot?
You are, but you need
I might have missed a scenario, I'm sorry, I'm holding the class up. You know what, you should just go forward, and I'll talk to you afterwards.
Okay, you're buying the floor area from them. That's what it's all about, it's all about.
What does that mean? Does that mean you're buying the land from them? Like,
No,
buying the ability.
you're buying the unbuilt capacity of the
So you're
land.
buying air rights from everybody though?
Yes,
I thought you just, isn't there a situation where you want everyone to be part of your zoning lot, right?
in order to buy air rights from them, or because in order to get to them, I have to go through them.
Right,
So I'm not buying air rights from them.
that's what, no, but that's what I'm saying, like,
Oh, right, I have to pay them anyway, because why on earth would they wanna get involved with me unless I pay them? Now, I'm not gonna pay them, I'm not buying air rights from them, so I'm not gonna pay them, let's assume it was $100 a square foot for air rights now. I'm not gonna pay them, you know,
but you need to pay for their cooperation to be part of the zoning
exactly,
lot.
that's
So
all
how-
negotiable, who knows?
Oh, so that's just kinda like, you just figure it out as you go.
You and they, you ask for, you say, well, you're not giving me anything, I should pay you $100, and they say, but you couldn't get there without me,
Exactly.
I'm gonna
That's
charge
just-
you $1 million.
I get what you're
It's
saying.
all negotiation, there's no,
They don't, that lot technically doesn't have air rights to sell,
correct, but it has to, it's selling its ability to merge.
but you're still.
You're
affected
paying
negative-
for it,
you're still-
as Alex said, you're paying for its cooperation. Okay. Any final questions, cause we gotta move on. Okay, we are done with New York City, we are done with zoning. I don't mean we're done with zoning, we're done with New York City zoning. Okay, we are moving on to planning. We're just gonna do this quickly, which we didn't do when I had it down on this thing. So planning. Planning existed before zoning, right? Cities planned. England, there was planning going on, so planning existed before there was zoning. Right, people planned. Washington DC was planned by L'Enfant in the 1700s, 1800s, I guess. No, 1700s, whenever. Philadelphia was planned. Right, so planning, so what's the difference between, so when we use the word plan here, we're talking about what people also talk about as master plan, comprehensive plan, right, city planning. So a plan can cover a small area, a plan can cover an entire city, a plan could cover a region, right, there's no restriction, limit, definition of what exactly a plan is or what it has to cover. So planning and zoning both deal with land use, right? Pretty,
Sorry.
can you actually, as long as you're there, can you put this light on? Oh, that's back you, can you put the light on? Thank you, yeah, well, right. So planning and zoning both deal with land use, right? I'm planning the development. What's the difference? Zoning deals specifically with, right, what's zoning? The division of land into districts. It deals specifically with land and the rules related to development. Planning is conceptually bigger. Because and by that I mean zoning deals with what zoning is. We've talked about for the rest of the semester, the previous portion of the semester. Planning could include so many other things, right? Planning can include sort of goals for development. It can include plans for infrastructure. It can include growth targets, right? Zoning doesn't have targets. It sets the rules. Planning is really kind of the future planning. Think of it as making a plan, just in common parlance, the word plan, for the future development of a city, right, or development of an area. Zoning, planning will probably always include zoning, but zoning doesn't include planning. Now remember, zoning is supposed to be, under the Standard Zoning Enabling Act, zoning has to be prepared in right connection with a comprehensive plan, right? But in a lot of places, it is, the courts have said, right, zoning, if you're doing a comprehensive zoning ordinance, that is the plan. But when we think of planning today, and what we're thinking about is not just the zoning ordinance, but we're thinking of more. Where are the streets gonna go, right? Where is the city gonna build the streets? Where are the parks gonna go? Where are any of the utilities gonna go? All of that could be part of planning. Now the first sort of bigger plan, it came out actually in the 1890s. There was something called the City Beautiful movement in the US, which was, as you know, as we were getting a lot of urbanization, there was this goal to beautify cities. And it was really about physical improvements, not about zoning, but about making a city look prettier, making the buildings look prettier. Chicago in 1909 was the first city to adopt a comprehensive plan for future development. Yes, we had the L'Enfant Plaza, we had Philadelphia had plans. They were plans for the physical layout. They were really like plans for the physical layout of the streets. Right, that's what L'Enfant did. He created those, right, diagonal lines and streets. That was a plan. A couple of definitions. City planning is the attempt to exert a well-considered control on behalf of the people of a city over the development of their physical environment as a whole. Right, which I think is a pretty good definition of what it is. It is a policy instrument. A plan is really a policy instrument. It's setting the policy for whatever it's covering. Now so there were some states, so the language in the Standard Zoning Enabling Act about, a well-considered plan. Some states had accepted the zoning ordinance itself if you have an overall comprehensive zoning ordinance, that was the well-considered plan. And some communities, however, even historically, the court said, no, you actually have to have a separate plan. So in those states where the courts said you had to have a separate plan, there had to be a separate plan. A city couldn't adopt zoning until it adopted a comprehensive plan. But those early comprehensive plans were very limited. They were really just about zoning primarily. They talked a little bit more because they talked about planning, but they were sort of limited to zoning. Starting in the maybe 1980s, 1990s, states started to recognize that planning was critical, that it wasn't enough to zone, that you had to have planning. And that planning wasn't just about what was the physical zoning going to be of the city, but that it involved all of these other things. Future growth, future development, layout of a city, infrastructure, everything that related to a city. And then another definition is planning balances the public and private concerns and ensures efficient patterns of spatial development. Coordinating public and private investment decisions. So it's really about, so in New York, so in the 1980s, New York City created Battery Park City and then Battery Park City. Created zoning districts for Battery Park City. And at some point it rezoned Tribeca to allow residential use. But city planning only does zoning. So, all of a sudden, Battery Park City was hot, had all this residential development, Tribeca was getting all this residential development. There was tons of residential development down, near Battery Park City and Tribeca. But there was a small problem. Because the city didn't plan, all these families moving there weren't any schools. Because the city didn't consider planning, right? The city didn't say, oh, we're having 5,000 new residential units developing. Maybe we should think about, do we have enough schools? And no, it was a huge issue in the early 2000s. There were not enough school seats for kids who were growing up and living in Battery Park City, Tribeca area. Why? Because there was no planning. New York City doesn't plan. New York City zones. It doesn't plan. Now, the newer rezonings, all of de Blasio's rezonings, have encompassed and have incorporated a lot of these other things through city planning because that's been the huge issue everywhere. But there is no comprehensive city plan. Now, maybe you don't need a comprehensive city plan, maybe you do, for the whole city. Maybe you can do area-specific planning. So some of the new de Blasio rezonings actually have involved some degree of planning. Most states historically have not required that there be planning or comprehensive planning. Again, so starting in the I think it might have been the 80s, states started to think about this. And they started to require that before cities take any zoning actions, well, first they started to require plans. They started to require, some states require that cities adopt plans. Well, for example, in California, cities have to adopt comprehensive plans. Actually, in California, they're called master plans. Maryland, cities have to adopt comprehensive plans. Florida, cities had to adopt comprehensive plans. And not only do they have to adopt comprehensive plans, but the state law in all of the states where the state requires that cities adopt comprehensive plans, the state sets out the limits. What does that mean to say a comprehensive plan? What does it have to cover? So, no two are exactly alike, but among the things that state laws requiring comprehensive plans require are actual zoning, capital improvements, future land use, traffic circulation, utilities, natural resources, housing, coastal management, intergovernmental coordination, regional needs, economic development. State laws require, so Florida has to consider most of those. When a city adopts a comprehensive plan, it has to plan, it has to think about all of those. So what does that mean? So for example, here's my city. I'm going to adopt a comprehensive plan. So what the first thing I do to develop a comprehensive plan is I have to look at the data. What do the data show? The data shows that my city is expected to grow, right? It's expected to gain 50,000 people, let's over the next 20 years. Right? Let's say that's what the statistics show, that's what the data shows. And you have to have a timeline. 20 years is usually kind of, a lot of plans have a 20-year timeline. my city's gonna grow 20 years, 50,000 people over the next 20 years. Right, so that's the first thing I've established. Now, where are we gonna put those people? Well, let's see. We've got a flood zone over here, right, this whole area is a this is a wetland, right? We've got a river and we've got a flood zone here. Let's call this a flood. It's land, but you know, it's low-lying, it's not great. Maybe we've got railroad tracks here. We've got some mountains here. There's a giant highway. We've got a major highway that runs through the city here. Okay? So these are facts. This exists. So when I'm thinking about where I'm going to put my 50,000, I have to think, where is it reasonable? Well, what exists here now? This is a railroad, right? This was a highway. So the city's going to think about, where does it anticipate? Where should we plan? Where do we want those people to go? Well, we don't want them to go here. So maybe, and this is good, we don't want them in the mountains, but maybe this is a good place for it. Maybe that's a good place on the other side of the highway. Okay, well, if we're gonna put people here, where are we gonna have jobs? What are we gonna do about jobs for them? Where do we expect jobs to grow? Where are we gonna allow for growth of jobs? Well, if I'm gonna have all these people here, I need infrastructure. Do I need to plan for more roads? Where am I gonna put my future roads? Do I have environmental? Well, we talked about the environmental issues. So they will think about all of these things, right? They're planning for the future growth and development of the city, and they're gonna come up with a plan that talks about, right, this is gonna be your high density, this is your, I'll make this right, we'll call this an R10 here in this city. R10 is high density. This would be an R1, because next to the mountains. We'll call this the low density R1, and maybe what I want here is I want my manufacturing here right next to the railroad. And I want my commercial here right next to the highway. And maybe the other side of the highway is next to some towns, some small towns over there. So I want my sort of high density residential here next to the highway. Plan this. But we know we're gonna need a school here, and another school here, and another school there. We're gonna need parks, and all of that is encompassed in the comprehensive plan. Florida used to require that plans be updated periodically. There was the statutory requirements. They're not so much followed anymore. They've all been amended to make it less significant. Now, in many of those states, so remember, the Standard Zoning Enabling Act required that zoning be consistent with a comprehensive plan. But again, as I said, the zoning ordinance. But in many of those states that are now I'd say all of the states that are now requiring that cities adopt comprehensive plans, the cities also require consistency. They require that the zoning ordinance be consistent with the comprehensive plan. I don't remember if I talked about this when I was talking about vesting. Development in Florida, a developer in Florida, comprehensive plan called for that area to have a certain kind of, right, a comprehensive plan doesn't say, for example, this is going to be zoned R1. Comprehensive plan wouldn't say, this is going to be zoned R10. The comprehensive plan would say, single-family residential development is appropriate over here with lots, with large lots because it is environmentally sensitive land. That's all it might say. It might have more specifics. It might say high-density development is appropriate there. Then the zoning ordinance would be adopted that said, okay, high density is appropriate here, we're going to make that an R10. If an ordinance has to be consistent with a comprehensive plan, so let's assume this is my zoning ordinance, and this is all R1, right, this is a city, so this is all R1. Everything in here is R1. We have only two kinds of residential development in this city. We have single family and we have multifamily. There's nothing else. This multifamily, this is all single family. The city says, wait a minute. I want to, you know what, we need more, right? There's this big, couple of you read the articles recently, there's a big push now to rezone some of these single family neighborhoods for multifamily. And let's assume the comprehensive plan in this city said, this area should all be zoned for single family, very low density, large lots because of the environmental sensitivity of the land. All right? And the city says, wait a minute, that's discriminatory, we want to change that, and instead we want all of this to be allowed for up to 4 families. Right, 4 family zoning, right? You know, in other words, you could build small, you know, apartment buildings or row houses or whatever of 4 families. Can the city adopt that zoning ordinance? What do you think?
Can they adopt it?
Would that be a valid action by the city to adopt, to rezone that area from R1 to, let's call this R4?
Well, that would be a process, right? That would probably involve the public or not necessarily?
Well, there's a process for rezoning. There's always a process for rezoning. They comply with the process. Can they rezone it?
Yeah.
Well, is it consistent with the comprehensive plan?
Well, it's adding another.
Is it, the comprehensive plan called for this area to be single-family, large lot zoning? Can the zoning ordinance be amended to call that now 4-family, right? We can create these instead of single-family lots, these are 4-family lots? Can the zoning ordinance be amended?
I would think it'd have to be an amendment process to allow.
Well, forget whether there's an amendment process or not. Clearly, there's an amendment for the zoning resolution. Zoning resolution, or the state law is gonna say, to amend the zoning resolution, this is the process you follow. So they can technically, a city could technically adopt this rezoning. Is it valid, I guess is what I'm saying. When I say can they do it, I mean, would it be valid?
Yeah, if you're having affordable housing issues or other things like that.
But why? The comprehensive plan says it's a single-family housing. How can I rezone it to be a 4-family unit? Comprehensive plan didn't discuss affordable housing.
Yeah, but now it's an issue. It wasn't an issue before, and
Okay, my comprehensive plan still calls it for single-family housing.
Change the comprehensive
Cut.
plan.
That's the answer. You cannot change, if your zoning, if your state requires consistency with a comprehensive plan, you cannot change the zoning unless you also change the comprehensive plan. Yeah, every city's gonna have, there's gonna be a process for changing comprehensive plan. You can update comprehensive plans. But if you don't change it, that is invalid. And if I didn't give you this example, I will quickly give it, and then we will go. Florida Development got approval from a city to build essentially small multifamily buildings. And the neighbors said, wait a minute. And it wasn't as simple as multifamily and single family. It was a lot more complicated about exactly what the density was, but let's just leave it for this purpose. This comprehensive plan called for this to have no more than 2 family units. You can't build, or no more than 2 family units. You can't build 5-story, 5-family. You can't build small apartment buildings here. That's what the neighbor said. And the city adopted the rezoning anyway. And the neighbors sued. And the court upheld it because it was not consistent with the comprehensive plan. Wait, it goes even further. The developer had started to build. He started to build buildings that would not have been valid, that he couldn't build under the 2-family zoning. he had no vested rights. Even though Florida accepts equitable estoppel, he had no vested rights because he had been put on notice by the neighbors that there was this issue. So it was not reasonable for him to rely. And he had to demolish him. That's what the court said. At the end of the day, I don't know whether the city amended its comprehensive plan or what happened there. But before you even got there, as a legal matter, it was inconsistent with the comprehensive plan and therefore was not a valid rezoning. So if consistency is required, you can't just go in, even if the city does it, doesn't make it valid. So, for a while, more states were increasingly adopting comprehensive plans. But over time, I think as the politics have changed, I'm not sure. California, though, is very serious. They're called general plans in California. I said master plan. They're called general plans in California. They also have local, smaller ones called specific plans. But California, if you want to do something, you need to amend it. You need to read your comprehensive plan. You need to know what a comprehensive plan calls for. And if necessary, you have to go through whatever the process is, assuming you can't amend the comprehensive plan. You might not be able to amend the comprehensive plan easily. It may be more complicated, but you have to keep that in mind that you have to. Okay.